2022, we had the Lancaster Conference, where a document was discussed with the late founding fathers of this country, Jaramogi Odinga, the late Mzee Jomo Kenyatta, and the likes. And that document came to be known as the Kenyan Constitution that gave birth to the Kenyan Republic in 1963. That was the constitution that was in place up to the 27th day of August 2010. In that constitution, there was no office of the ODPP. The office that was there was the office of the Attorney General. The Attorney General was the principal chief advisor to government on civil matters and criminal matters. That was the document that ran up to 2010. Under that constitution, a department was created under the office of the Attorney General called the Office of the Deputy Director of Public Prosecution. The likes of Bononga, the likes, those guys, Chunga, all those guys were prosecutors under the Attorney General. They recruited police officers who were prosecutors in court. The police could arrest, could investigate, arrest, and prosecute. That was the law up to 2010. Kenyans were asked, do they want to proceed with that way of prosecution? Kenyans raised serious issues because the argument was a complainant cannot be an investigator and be a prosecutor. The Kenyans decided to reject that position. And in 2010, the Kenyans created Article 157 of the Constitution of Kenya, which created the Office of the Director of Public Prosecution, which has a constitutional tenure of 8 years, which has a constitutional mandate to prosecute. That act, that constitutional provision, can only be amended through a referendum. It cannot be amended by an act of parliament. Article 79 creates the EACC. On the 27th of October 2010, Kenyans created EACC as an office within the Constitution with a mandate to investigate only one crime: economic crimes. It created Article 244 and 245, the Inspector General of Police, with a mandate to investigate both economic crimes and any crime committed in this country. Out of that constitutional framing, the EACC and DCI have similar powers to investigate economic crimes. That is the Kenyans speaking. And this is clear. Therefore, the crazy move for the EACC to seek through statute to amend constitutional provisions does not have any legal basis or any constitutional basis. If you remember, at the BBI draft that the courts called hotel, the Supreme Court called it hotel, provisions and articles of EACC were to be amended to have those powers. EACC lost badly. They know if they want to have prosecutorial powers, they can only do that through a constitutional amendment. Among the reasons the BBI was called hotel is the question that within the between the BBI provisions, the powers to prosecute had been granted to the EACC. That is one of the reasons they should read from the constitutional what the Supreme Court said as the reasons to throw away the BBI. That is still the law of this country. Number two, EACC is claiming they want to investigate and prosecute. Three things come into play. The DPP, out of 100 files forwarded to the office of the DPP, the files that go there, out of 100, only one belongs to the EACC. 99 belong to the Inspector General of Police. EACC, because EACC, KRA, Director of Immigration, and the DCI are all customers of the Director of Public Prosecution. The DCI handles over 99% of the workload of the DPP. What makes EACC feel superior, feel entitled, other than the DCI? If you check this country, the criminal courts in this country handle in a year more than 50,000 criminal cases, the whole country, plus the anti-corruption courts. The anti-corruption matters cannot be 20, or they cannot run. They are not per year. They are not more than 20. The DCI runs thousands matters in court.